Oyez, all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-5255. KO, buying for their parents and next brands, EO and LJ, et al., appellants, versus Jefferson B. Sessions III, former Attorney General of the United States, et al. Mr. Cacase for the appellants, Mr. Byron for the appellees.
Good morning, Mr. Cacase. You can proceed.
Good morning, Your Honors, and may it please the court. Joseph Cacase on behalf of the plaintiffs' appellants. The plaintiffs are children who were brutally and forcibly separated from their parents at the border after entering the United States seeking asylum from dangerous and life-threatening conditions in their home country here, Guatemala. The plaintiffs here seek to hold the defendants liable in damages for that conduct, for forcibly separating them and thousands of other young children similarly situated from their parents while held in immigration detention after coming to this country seeking asylum from dangerous and life-threatening conditions in their home countries, which were mostly in South and Central America. The defendants...
Excuse me. Isn't it true that the plaintiffs in this case have also brought a Tort Claims Act?
Yes, that's correct, Your Honor. We initially sought leave.
From the newspapers, I gather that's in negotiation with the Justice Department.
It no longer is, Your Honor. It was, but no longer is.
Oh, but it's proceeding as a Federal Tort Claims Act.
Correct. Our federal tort claims, we sought to amend to include in this case that's on appeal before the court. However, Judge Contreras denied our motion for leave and suggested instead that we file a new action for various procedural reasons, which we've done. So that Tort Claims Act case is pending in Massachusetts with a motion to dismiss expected from the government later this month.
Well, doesn't that satisfy one of the factors that the Supreme Court looks at in Bivens' action, whether there's a other method of seeking relief? And sometimes the court will look to equitable relief as adequate even when damages are sought. But here you have damages and damages.
Sure. So thank you, Your Honor. Let me address that in two ways. First, those factors are only relevant if what you're dealing with is a new context. And as we argue here, at least three of the claims are not a new context. And I can come back to that. But to address Your Honor's question, assuming the context is new, a tort claim remedy is not an adequate alternative remedy, even under the Supreme Court's case law. And there's a few reasons for that. First, the Tort Claims Act itself includes an exception, an express exception in Section B2A for constitutional claims.
Excuse me, I point to that. That means Congress didn't wish to preempt that, but that's still totally up to the judiciary as to whether a Bivens action is appropriate. And certainly that statute is referring to doesn't indicate whether Bivens acts are appropriate or not.
Correct. But what it does recognize and what the Supreme Court in Carlson has said and reaffirmed in Hui versus Castaneda is that it's crystal clear, as Carlson held, that Congress views the Tort Claims Act and Bivens claims as parallel complementary causes of action if recognized. And one of the critical distinctions here is that a tort claim, of course, is against the United States. A Bivens action is against the individuals responsible for the conduct at issue. And so where Bivens and its subsequent cases, including Ziegler versus Abbasi, recognize that the two purposes of a damages remedy and a damages action are, one, to provide a remedy for past harm done to the plaintiffs, but two, to have a deterrent effect. And a Tort Claims Act that proceeds just against the government does not have the same deterrent effect that an action proceeding against the individual does. So for those reasons, Your Honor, yes, there are Tort Claims Act claims pending, but those are not sufficient to counsel hesitation. While that is true, it's not a special factor that's sufficient to counsel hesitation here. And if I could,
you also have APA claim and claim for injunctive relief that are available to you, right?
Correct, Your Honor. And those have been filed in other contexts, but I think they're sort of similar to, in some ways, the claims for injunctive relief or habeas relief are sort of in one category, and those are designed to achieve prospective relief, right? They do not provide a remedy for prior harm, and they don't deter future violations the way that damages actions do. And the Supreme Court in Abbasi said that if equitable remedies prove insufficient, a damages remedy might be necessary to redress past harm and future violations. And I would point to the fact that the same counsel that has obtained some of the nationwide injunctions, including in Mizell in California, on these very issues, did file a Bivens action as well as tort claims separately, precisely for that reason, because injunctive relief does not provide relief for prior harm and doesn't deter future violations. The Administrative Procedure Act, again, it was a basis for correcting some of the problems and a way to reunify families. But the Administrative Procedure Act doesn't provide a damages remedy, provides no way to remedy past harm. And it's focused on correcting procedural errors. And if you look at the Supreme Court's and this court's cases, relying on the Administrative Procedure Act as an alternative remedy, those cases typically involve things like the grant or denial of a license or permission or not to do something that can be remedied via an APA claim. The harm that's at issue here, trauma caused to these children from being brutally and forcibly separated from their families, is not something that can be adequately or remedied at all just from reunification. I mean, we've alleged in the complaint widespread consensus among experts, the American Pediatric Association and others, about the long-term harm and trauma that's expected to linger based on the defendant's conduct here. If I could, before the court even gets to that, though, there are three claims here that really don't present a new context, and therefore a special factors analysis isn't necessary. And those three are the three that are most parallel to and similar to the Supreme Court's the cases that the Supreme Court has upheld damages claims in, being Bivens, which upheld the claim in the Fourth Amendment search and seizure context, and we have an unconstitutional seizure claim here. Davis versus Passman, which dealt with equal protection violations under the Fifth Amendment's due process clause. We have a similar equal protection claim under the Fifth Amendment here. And then Carlson versus Green, which dealt with inadequate medical treatment in detention. And we have a similar claim here. It's under the Fifth Amendment as opposed to directly under the Eighth, but same substantive claim. So at least those three claims, Your Honor, we argue are not in a new context and don't even require a special factor analysis. Now, I recognize that I'm into my rebuttal time. I'm happy to continue answering the court's questions and to continue addressing our arguments if that would be helpful, but I'll defer to the court.
Does any of my colleagues have any further questions for counsel for appellant at this time?
Oh, thank you.
Thank you.
All right. Why don't you reserve this time for rebuttal then, and we'll hear from Mr. Byron.
Morning, Your Honor. May it please the court. Thomas Byron from the Department of Justice, here on behalf of the individual federal defendants in this case. The district court here faithfully applied Supreme Court precedent and correctly dismissed the individual capacity damages claims brought by plaintiffs in this case. As the court recognized, the new context inquiry here is not a close call. The Bivens claims against high-level executive officers concerning immigration enforcement policies ineluctably present a new context. And in a new context, when a court is being asked to extend Bivens, the question, as the Supreme Court emphasized in both Abbasi and Hernandez, is who should decide, courts or Congress? And the answer most often will be Congress, as the court said in Abbasi, and as in Hernandez, that is undoubtedly the answer here. That's so because there are multiple special factors that counsel hesitation before the courts undertake the legislative responsibility of balancing costs and benefits to create a new damages remedy. There are multiple comprehensive alternative processes available, including the Immigration and Nationality Act, the Trafficking Victim Protection Reauthorization Act, the APA and injunctions, as indeed several plaintiffs have sought relief successfully in those kinds of claims. And Bivens is just not a proper vehicle for altering an entity's policy or inquiring into policymaking decisions that would create an intrusion into the sensitive functions of the executive branch. Also, Congress's attention in this area, both generally in immigration and specifically with respect to the claims that plaintiffs have brought, has been frequent and intense, as the court noted in Abbasi, and congressional inaction was not inadvertent. Other separation of powers concerns similarly counsel hesitation and create further reason to support the district court's decision to dismiss here. The plaintiff's argument did not address the statutory conspiracy claims. I'd be happy to answer the court's questions, but otherwise would rest on our brief to address those issues. If the court has no questions, we'd urge you to affirm the judgment below. Thank you.
What about the argument of your friend on the other side that the whole, I guess, bevy of remedies are not sufficient given the type of harm that the plaintiffs are alleging here and that they seek redress for?
Judge Wilkins, I think that misunderstands the separation of powers concerns that the Supreme Court has emphasized in its recent decisions in this area. So while the plaintiff's argument is that retrospective harm cannot be remedied by prospective relief, that's true as well in the kinds of claims that the plaintiffs brought in Hernandez specifically, where the claim was the killing of a youth across the border, and there's no doubt that that harm could not itself be remedied prospectively, and yet the Supreme Court noted that Congress's inaction in declining to create a damages remedy against individual federal officers was itself significant because of the separation of powers concerns that drive the analysis in determining whether the courts or Congress should be charged with balancing the costs and benefits of determining whether to create a new damages remedy.
Of course, that argument could be seen as an attack on Bivens itself.
Well, Judge Silberman,
you don't want to do that, do you?
No, Your Honor, we don't. And we don't think it's necessary for this court to address that question.
Well, we wouldn't be able anyway.
Of course. And the Supreme Court...
But is there, does one get the impression, reading Justice Kennedy's opinion in Abbasi, that it's really unlikely the Supreme Court is going to authorize any new Bivens actions that don't fall within the exact category of Bivens, Carlson, and Passman?
Well, Judge Silberman, I think what the Abbasi opinion makes clear is that there is a context-specific analysis required in any new Bivens claim, in any new individual capacity damages claim. And that two-step framework that the court set out in Abbasi and reaffirmed in Hernandez makes clear that the context of each case is important, and the analysis of the special
You're
factors.
not answering my question. You, as a lawyer arguing for the government, would you agree that from the Kennedy's opinion, you get the distinct impression the Supreme Court's not going to go beyond the three examples they already have authorized?
No, Judge Silberman, I don't think it's fair to read the opinion that broadly. And I think that question is presented in the pending case in Boulay against Egbert right now. We'll see what the court says about it. But again, I just want to reiterate, I think the framework the court established in Abbasi is very clear, and its application in this case is quite straightforward, as the district court explained.
Fair point.
Thank you, Your Honor. We urge the court to
Further
affirm.
questions?
Thank you.
No, thank you.
Thank you, counsel. We'll give Mr. Cacase 2 minutes in rebuttal.
Thank you, Your Honor. And if I can, use part of my time here to address the statutory claims, since we didn't get to them before, I'd like to do that just very briefly. And the only issue on appeal on the Section 1985 and 1986 claims is whether the defendants are entitled to qualified immunity. It's, of course, their burden to establish that, and it fails really for three reasons. First, the operative question, as the Supreme Court made clear in Tolan versus Cotton, is whether the defendants violated clearly established statutory or constitutional rights of which a reasonable person would have known. Here, and under 1985, the question really is whether it's the equal protection allegation is clearly established. Here it is, and we included in our brief arguments on why the equal protection claim is clearly established. And so that's what's relevant. What's relevant is the right, whether a constitutional right was clearly established and a violation of that right was clearly established. The precise statutory theory of liability is not what's relevant to the qualified immunity analysis. And so, looking through every element of 1985 to see if it was clearly established is not what's required. But even if it is, it's very clear that the intercorporate conspiracy doctrine only applies when you're dealing with a single entity. And so in this context, that would be, as in Abbasi, a single department or a single agency of the executive branch. But the defendant,
that's a disputed issue, is it not?
Well, the defendants, Judge Silberman, have not pointed to any cases in which a court has held or even questioned whether multiple federal agencies could conspire together under Section 1985. It's only in situations, and Abbasi didn't deal with that. Abbasi only addressed that question because it was presented with the issue of whether individuals within the Department of Justice could conspire with each other, within one single entity. The cases like
the Constitution creates a single executive branch, right? All executive powers vested in the president. That's arguably one constitutional entity.
Correct. It creates one branch, but for purposes of analyzing whether a conspiracy exists between federal officials in different branches, which are treated in the law as different entities. I mean, if a case is brought against an agency, it's filed against that agency or sometimes the head of that agency and not against the United States, right? So I think it's clear if you look at the cases and even the district court cases in this district, like Tripp versus Executive Office of the President, and Lerner versus District of Columbia, where they hold that the intracorporate conspiracy doctrine applies, you're dealing with people outside of one department, and oftentimes people outside of the government, which we actually address, which we include in our allegations here. If you look at paragraph 30 of
Judge Varral recently wrote in an opinion, you have to serve if you're suing the Department of Agriculture, you have to serve the Justice Department, reflecting her view that, after all, we're talking about a unitary executive.
Sure. Well, Your Honor, I mean, notice needs to be given to the Department of Justice, who would be responding to that on behalf of the agency. But I don't know that it necessarily changes the analysis. But the other important fact here is that we also allege in the amended complaint in paragraph 30 that private contractors, ORR, Office of Refugee and Resettlement Contractors, were involved here. Were involved in the conduct and were involved in the conspiracy. And there's no question that to the extent that's the case, the intracorporate conspiracy doctrine wouldn't apply. And then finally, just very briefly, there is a clearly established official misconduct exception to the intracorporate conspiracy doctrine, which would apply here based on the allegations in the complaint. So with that, Your Honors, I'll rest on our briefs unless there are further questions, and just respectfully request that the court recognize the historic wrong that was done here and allow this case to go forward to remedy the enormous harm and long-lasting trauma that was done to the plaintiffs and other children forcibly separated from their families, and to deter this from ever happening again. Thank you, Your Honor.
Thank you. We have your argument. We'll take the case under submission.
Case number 21-1163 et al. Cherokee County Cogeneration Partners, LLC, petitioner versus Federal Energy Regulatory Commission. Mr. Hughes for the petitioner, Ms. Berry for the respondent, Mr. Zetling for the intervener.
All right, counsel for petitioner, we will hear from you.
Good morning. May it please the court, Paul Hughes for petitioner, Cherokee County Cogeneration Partners. There are a few essential points that are not in dispute in this case. The first is the existence of the comparability principle under the Federal Power Act. That arises from the statutory requirement that a public utilities rates must be non-discriminatory. The second is that a generator may normally bring a FERC Section 205 proceeding to enforce its rights under this comparability principle. The question presented here is whether FERC's regulation implementing PURPA has stripped FERC of this jurisdiction. Generally, FERC does have jurisdiction.
There are two factors, right? When you look at the regulation, which you don't challenge. One of which, of course, is the argument you raise in your brief to this court that the element of power you're talking about is not energy or capacity. That's one factor.
Yes, Your Honor.
And the second factor is whether or not the arrangement was pursuant to PURPA, a state implementation of PURPA.
Yes, Your Honor.
So you can win on this case if you win on either factor, right?
Yes, Your Honor.
But the comparability question is subordinate to that, isn't it?
Well, I think it's the initial place to begin, Your Honor.
I don't see that because I'm looking at jurisdiction first.
Your Honor, I agree with everything you said. We have to win on one of those 2 points. And if we win on either of those 2 points, then FERC erred and the court would vacate and remand. So I certainly agree with
why don't you focus on those 2 points? Because there's a challenge to both of them by FERC here in this court.
Thank you, Your Honor. So to turn to the first point we raised in our brief, that this was not pursuant to a state's implementation of PURPA. The first point is FERC just did not address this precise argument. FERC addressed a different argument in saying that in its view, the interconnection agreement was quote unquote jurisdictional to South Carolina. But that's not what the regulation.
Well, first of all, the problem is, did you address the issue properly before this court? Excuse me, did you address it properly in the petition for rehearing?
Oh, absolutely, Your Honor. So, for example, at Joint Appendix page 352, we made this argument quite clearly. We said the commission's sole rationale that the interconnection is not subject to the commission's jurisdiction is simply irrelevant. And I'll stop reading, but we continue to go on.
I'm not sure I understand that the argument you presented in the petition for rehearing. What is the argument you presented in the petition?
So, with respect to this first element we're discussing, Your Honor, as to whether or not this was an implementation pursuant to PURPA, what FERC had said in the initial order is they had said that this is subject to South Carolina jurisdiction, not FERC jurisdiction, and they stopped. What we explained in our rehearing petition was consistent with our original answer, is that's asking the wrong question. The question is not whether it is FERC jurisdictional or South Carolina jurisdictional. It is whether it is pursuant to a state's implementation of PURPA. And those are not the same thing, and FERC didn't answer the right question.
But are these couple of sentences here on page 352 enough to preserve the issue under our precedents, which are really very strict?
I absolutely think so, Your Honor. We said in no uncertain terms, and when this continues on page 352, we made exactly the argument, as we said in this middle paragraph, rather, as explained in Cherokee's earlier pleadings, its sales of reactive service are not made pursuant to a state regulatory authority's implementation of Section 210 of PURPA and are instead fully subject to commission regulation under Section 205 of the Federal Power Act.
Well, why weren't they? You don't explain.
Well,
in the petition for rehearing what you argue before us.
Well, that is the essential gravamen of this argument, is that these are not subject or do not fit within that regulatory framework. And FERC has made quite clear what that means. In a 2005 regulation, this is 113 FERC 61020, paragraph 26, it says that these, quote, sales are at rates pursuant to contracts or obligations approved by state regulatory authorities. In South Carolina, and this is in FERC's brief at page 9, in the quote unquote small power production cogeneration facility order that they entered in 1981, that's Order 81-214 at page 11, it says exactly the same thing. Both FERC and South Carolina agree that to be pursuant to a state's implementation of PURPA, it has to be filed with the commission. And this large generator interconnection agreement, there's no evidence it was ever filed with the South Carolina Commission and doesn't qualify as a state's implementation of PURPA.
Isn't it fair to say that, well, here's the interesting question. The interconnection, if there had been a dispute concerning the interconnection agreement, to whom would it have gone?
It's not entirely clear, Your Honor, on the record. It's possible that that dispute could go to the South Carolina Commission.
It seems to me, obviously, it would go to the South Carolina Commission. So then, isn't it implementation of PURPA?
No, Your Honor, it's not an implementation of PURPA. Well, first, FERC never said it was an implementation of PURPA, and it may well not be, because there are other ways to have interconnection agreements that are independent of PURPA. So, for example, Duke has to have an open access transmission tariff pursuant to FERC rules. That's FERC Order 888, a FERC order that was implemented in 1996. That would be an independent standalone basis for the interconnection agreement that would be unrelated or irrelevant to PURPA. The essential point, though, is FERC didn't address whether or not this interconnection agreement was pursuant to PURPA, and that's the core issue. We're guessing here because
FERC did cite quite clearly and explicitly its Order 2003, cited it both in its initial decision and in its rehearing opinion. Wasn't that?
And Your Honor, that is. Sorry, my apologies.
Wasn't that the jurisdictional grounds that FERC relied upon?
And our essential point, Your Honor, is that's asking the wrong question or answering the wrong question. They said that it is subject to South Carolina jurisdiction. And our essential point on this first prong is that there are two distinct issues. To which is it FERC or South Carolina jurisdictional? That's one issue that FERC addressed. FERC did not address the separate issue of was this an implementation of PURPA. or pursuant to the state's implementation of PURPA. And the answer to that was unaddressed by FERC. And even the answering the question that it is subject to FERC jurisdiction does not answer that second question as to whether or not it is an implementation of PURPA. But again,
What did you say in the petition for rehearing on that question?
well, that's, I think, precisely.
You have one sentence, just as my colleague points out, but you didn't really make the argument you're making in your brief, or you're making here.
I think we do make precisely this argument in the brief, Your Honor, and what we're explained to FERC is they have to find a basis to say that this is.
Where besides that first sentence, what did you say?
Well, it's the whole paragraph, Your Honor, and then the analysis carries over onto to Joint Appendix page 353 as well. But in that paragraph, we explain that they make the argument about it being jurisdictional. We explain that that argument is irrelevant, that rather what the question is this pursuant to the state's implementation of PURPA, and that deciding the jurisdictional status is not deciding this separate, more precise question that's asked under the regulation. And so on that basis alone, we think the most straightforward disposition of the case is to recognize that FERC did not address the precise particular question that arises under the regulation that was presented to FERC. It did not answer this question after it was specifically teed up in the rehearing petition. And then the discussion we're having as to whether or not jurisdictional sweeps within that, that's the argument that FERC has made on the substance.
Now, I thought you were arguing here that FERC did not respond to the other question, which was the comparability standard. That's what I thought your major argument here was, or in the rehearing petition.
No, Your Honor, our point has been that FERC didn't respond to the fact that this was outside the scope.
Did you not make the argument they didn't respond to the comparability principle?
Oh, yes, we explained that as well.
And what's that got to do with the price of tea?
Well, Your Honor, that is part of the answer as to why the FERC's determination that this is subject to South Carolina jurisdiction is not the end of the matter, because there is separate jurisdiction under sections 205 and 206.
But I don't see what the comparability principle has to do with the PURPA question.
Well, Your Honor, the interconnection between those is because FERC seems to think that if this is subject to interpretation by the commission, by the South Carolina Commission, excuse me, that takes it outside of FERC and the comparability falls out, and that's wrong. And that's the point that we're making of why that's wrong.
The comparability goes to the amount of money you're entitled to, really. Well, doesn't really go to jurisdiction.
Well, I think it may go to both, Your Honor, because again, this presses back against FERC's merits argument that the decision by FERC that this is South Carolina jurisdictional, in their view, disposes of this case, because they suggest that takes the comparability claim off the table. And our explanation is that's just flatly wrong, because the comparability principle exists independent of the interconnection agreement. It exists under the principles of section 205 and 206, which apply unless they're stripped. And the court is quite correct in the initial question asked of me of, again, to find that FERC erred in dismissing, we do need to win on one of those two grounds. But the tie here is to explain why FERC's finding of that this agreement is South Carolina jurisdictional does not resolve the matter of the comparability principle. I'd be pleased to turn to the second argument for a moment, although I see over. Thank you, Your Honor. So
if you can take 1 minute.
Thank you, Your Honor. As to the second prong, we explain why reactive power doesn't qualify within energy or capacity. As we explain in our briefs, these are very technical terms that FERC uses with purpose, and throughout its regulations, it separately uses ancillary services, of which reactive power is part.
Counsel, I would make 3 points. The first of which is, I think you make an elegant argument in the brief on the energy and capacity point. However, number one, I think that argument was not presented in the petition for a hearing, and it is not covered by Columbia Gas, because from the very beginning, you should have been recognizing that you had to win on one of those two issues. So you had to present them in the rehearing petition, and you did not. And this is not like Columbia Gas, where the government or FERC comes up with an entirely new issue. It was an issue that you had raised in your initial answer, but you didn't raise in the petition for rehearing. So even though it's an elegant argument, I don't think it's properly before us, number one. Number two, it's elegant, but it's not very persuasive, in my view. So even if you lose on jurisdiction, I think you don't really, you're not going to win on your definition of energy. That's just one judge's view, but I'm impressed at the argument.
Your Honor, may I respond on the preservation question?
Yeah, that's the key. Without it, you're dead.
Thank you, Your Honor. And as the court recognizes, it was in the answer. We explained what the proper construction of 601C was at the outset of this case. FERC, in its initial decision, did not quarrel, did not object to our understanding of what 601C made. Instead, it made its preliminary.
Counsel, the problem is the petition for rehearing.
Well, and I'm setting the background for why it was this didn't have to be in the petition for rehearing, because there was no error in the original answer as to 601C. We explained what 601C meant in the answer. FERC did not quarrel with it.
Wait a minute. You recognize you had to win on one of these two, and you ignored the energy and capacity argument and petition for rehearing.
Well, because in the initial answer, FERC had made no quarrel with that. They had gone off the rails on a preliminary question. They had not made this error. And what I think Columbia Gas instructs is that we don't have to guess or predict an error that FERC might make upon rehearing. And I think that's the circumstance. And I think what's instructive here is FERC, when it actually moved past the jurisdictional argument, knew that this was in the case. They spent 3 pages of their decision across several paragraphs, in fact, actively resolving this issue. And I think the fact that FERC engaged in this analysis, rested its analysis on this, engaged with this, shows that FERC recognized it was properly within the case, it was properly before it on rehearing, and thus is properly an issue that can and should be considered by this court in this petition.
This is another example of cases we see where counsel and the D.C. Circuit presents a much more persuasive case than experts before the agency do.
Thank you, Your Honor. Happy to turn to the...
I gave a speech about that once.
Thank you, Your Honor. I think the court understands our position on the substance. We think that FERC knows what it means when it says energy, because it's written many regulations that distinguish energy ancillary services, and it treats those categories quite differently at times.
All right. I think we have your argument. Let's hear for counsel from respondent.
May it please the court, Lona Perry for the Federal Energy Regulatory Commission.
Counsel, you make some arguments which seem to me sort of silly. Number one, you argue it's moot. Why? There's money at stake here. If they're entitled to jurisdiction under your statute, there's money at stake. How can you say it's moot?
Yes, Your Honor, I understand. And having seen that...
You might have stronger arguments, but why make a really weak argument? And secondly, the argument that this was a declaratory statement that has no significance, as if this was an enforcement proceeding, also seems to me to be a rather silly argument.
The primary argument there, Your Honor, was that this court has held that there is no statute which provides for direct review of commission orders interpreting PURPA. And the point is, these orders
those are cases of an enforcement proceeding, but an effort to try to circumvent enforcement. That's not this case.
There are cases where there are petitions filed directly with the commission that the commission acts on, and this court has said that there is no jurisdiction over those because they only interpret PURPA. So we felt that it's an issue that had to be raised because this court has said that commission interpretations of PURPA are not subject to direct review.
All right. Let me go to the issue that puzzles me no end. What is the relationship between the two criteria by which PURPA jurisdiction is established, we just discussed. What is the relationship between that, on the one hand, and whether or not the cogenerator is selling to more than one customer? What is the relationship between those two concepts?
The relationship between those two concepts is that the mandatory purchase obligation under PURPA only applies to the extent that the utility is purchasing the total output of the qualifying facility.
So the moment the generator sells to more than one customer, they're out of PURPA as far as you're concerned.
Then it becomes commission jurisdictional then, because it is selling in interstate commerce to a third party. But I don't know why you say interstate. It's selling wholesale, which could be two companies in South Carolina. It doesn't have to be interstate. The point is, what PURPA did was it prevented qualifying facilities who interconnect with the grid from being considered FERC jurisdictional just because of that. But the point is, if they connect to the grid and then their power is transmitted in interstate commerce to a third party, then that does become FERC jurisdictional. The PURPA situation is where they entirely sell all of their output to their interconnecting utility. And so under PURPA gave an exception for that. So that is only state jurisdictional. Okay, all right. So in other words, if a cogenerator sells to more than one, it sells 10% of its power to another customer, it's out of PURPA? Well, it's out of state jurisdiction. It can still be a qualifying facility. Well, that's what I thought. You said a moment ago it couldn't be a qualifying facility unless it sold all its power to one customer. No, it's not state jurisdictional. I'm sorry if I misspoke, Your Honor, but it's not state jurisdictional if it sells to more than one party, which is what Order 2003 says. So in other words, it's still PURPA. It can still be PURPA. Okay, that wasn't clear in your briefs. I was a little confused about that. Yes, Your Honor, but it's just what we're talking about here is where the transaction is entirely within it. They're selling all of their output to the one interconnecting utility, then under PURPA defines that as being a state jurisdictional. So why was there ever any discussion about selling to a second customer? I don't even understand why it was in your briefs. The reason it was in the briefs was just because below, although they haven't raised it here, but below, one of the rationales that the petitioner relied on was the fact that they were planning, perhaps, if the purchase agreement was not renewed, to sell to third parties. And so you're raising an issue in this Court of Appeals that wasn't raised below? Well, it was raised below, but they haven't pressed it. It's not in their briefs. It's not anywhere. So I'm sort of mystified. Okay, so the bottom line is it can still be PURPA if, pursuant to PURPA, even if there's a sale to two customers. It's not state jurisdictional under PURPA if it's the sale to two customers. And this goes to the implementation. So then it would be FERC's jurisdiction. That's right. For both parts, for both the original sale and the secondary sale? There could be circumstances where some of the sales are jurisdictional to FERC and some are not. Well, how? Why? Well, it depends. But the point being in this case is that what PURPA said was if all of your output is being sold to your connecting utility, then that is state jurisdictional. And therefore, that sale plus the interconnection connected with that sale are necessarily within the state's implementation of PURPA. All right, what about they can win on either argument. You make a very persuasive argument that they forfeited the energy and capacity. They didn't raise it in the
petition for rehearing. Well, what about pursuant to purpose? As they point out, they at least have a couple of sentences raising that argument. If they win on that, they win.
I agree, Your Honor, that with the discussion earlier, that there is only this one sentence in the rehearing request at JA 352 that says, as explained in Cherokee's earlier pleadings, its sales of reactive service are not made pursuant to a state regulatory authority's implementation of PURPA. And then there's a cite to 292.601, and that's the only reference to 292.601 anywhere in their rehearing request.
Well, let's assume they made the argument properly. Then what about, they certainly make the argument before us. And how do you respond to their argument that South Carolina did nothing, nishta? Excuse me, that's several equation. You shouldn't have done that. But South Carolina did nothing, so there's no implementation of PURPA. What do you say about that?
I would say that that's not the case at all, Your Honor. In the first place, they are citing for this purported requirement that—
Wait a minute, did South Carolina do anything about this?
Well, certainly, South Carolina approved the purchase agreement.
But that's not the key, is it? What about the interconnection agreement?
Well, the interconnection agreement, the commission pointed out at JA 7, note 36, in the initial order, the commission pointed out that a schedule of the purchase power agreement itself specifies that interconnection service must be contracted for separately pursuant to the South Carolina generator interconnection procedures. And so the purchase agreement itself that South Carolina approved said specifically that service must be contracted for separately pursuant to their state interconnection procedures.
Yes, but the petitioner's argument is that the reactive power, what is it called, reactive power?
Reactive power, yes, Your Honor.
Subordinate, it comes about because of the interconnection agreement, not the power agreement.
But that's the point, Your Honor, is that the interconnection is also under South Carolina's jurisdiction. Specifically,
But did South Carolina do anything about the interconnection agreement?
South Carolina,
Did they?
Their argument that South Carolina was required to approve
Why
the
don't you
interconnection.
answer my question? Did South Carolina do anything?
I am not sure, Your Honor, what South Carolina did with respect to the interconnection agreement, and there was nothing in the record that said one way or the other what they did. But there is nothing that requires that South Carolina approve this individual interconnection agreement. The reference that they make to the requirement that, now I can't find it. The reference that they make to the requirement that that it be filed is a statement from the notice of proposed rulemaking at 113 for paragraph 61020 at paragraph 26. And I will note that that language that was discussed in the notice of proposed rulemaking that they are citing to was not the language that was adopted in the final rule. If you look at paragraph 671, you will see there that the commission says in paragraph 99 that it is not accepting that language that it originally had in the notice of proposed rulemaking. And this is at 114 for paragraph 61102. But they are adopting the language which is at issue here, which is pursuant to a state regulatory authority's implementation of PURPA. So the site that they are giving for the requirement that South Carolina approve this interconnection agreement, nothing says is not applicable because it's not even talking about the same language.
Well, what is your view of the laws? If I can bring you back from the weeds, does South, in order to have an implementation according to PURPA, does South Carolina Commission have to do anything? Let's just assume a blank slate.
The commission and the Supreme Court, and if you look at FERC versus Mississippi, 456 U.S. at 751, made the point specifically that states have latitude in their implementation of PURPA. This commission was not directing that they exercise their jurisdiction in any particular way. They could issue regulations. They could resolve things case by case.
Counsel, you're not answering the question. If South Carolina does nothing at all, hypothetically, is that implementation of PURPA?
It's when you say they do nothing, the point is they have interconnection procedures. They haven't done nothing. And the question is whether they have to have they have to approve each individual interconnection agreement, but they have interconnection procedures. It's not that they have done.
Well, that's like saying they have regulations, but is it implementation under PURPA if they do nothing with respect to this interconnection agreement?
Implementation of PURPA is specifically can be.
Your theory is it was under South Carolina's jurisdiction. If there was any problem, it would have been brought up before South Carolina. Therefore, it's implementing pursuant to PURPA. That's right, implicitly your argument, isn't it?
That's right, Your Honor.
Why don't you just say it? But you know what? I'm not sure you're right about that. But in any event, I understand your argument.
Yes, Your Honor, and I would like to point out again, the record does not show what South Carolina did with respect to nobody even put the agreement into.
It's a fair point.
So we don't know what South Carolina did with respect to the interconnection.
I was just trying to understand what the law was.
I have a question about reactive power. Mm-hmm. And just if you could explain to me, is reactive power can sometimes be an ancillary service? Is that right?
Yes, it can.
Mm-hmm. But not in this circumstance. So how is this circumstance different from a situation in which it's an ancillary service?
It goes, Your Honor, to the language, the language of the PURPA regulations that are issued here, specifically the phrase energy and capacity, or energy or capacity, which is used throughout the PURPA regulations. If you look at paragraph 16 of the Commission's rehearing order, it points to the fact that at Order 671, where these regulations were adopted, the order talks about electric energy, not energy or capacity, even though that's what's used in the regulations. And the reason why the Commission does that is because the PURPA statute says electric energy. And so the regulations...
That's one part of your argument. The other part of their argument is that it's an ancillary service.
Well, if I could, Your Honor, in Order 671, they talk about Order 69. 69 is where they first adopted the PURPA. Order 69 is where they first adopted the PURPA regulations. And when they were adopting those PURPA regulations, there were people who argued, much like the petitioners do here, that the PURPA statute only says electric energy, and therefore we don't have to pay for anything except for the costs of producing the energy, the variable costs of producing the energy. We don't have to pay for the capacity, for example, that is needed to produce that energy and the fixed costs associated with that. And the Commission rejected that argument because it found that electric energy, and this is at Order 69, 45 Federal Register at 1225, the Commission rejected that specifically because it said electric energy in the PURPA statute is intended to have the same scope as electric energy does in Section 205, which means that everybody acknowledges that under Section 205, which says electric energy, just like PURPA does, everybody acknowledges the reactive power is within the scope of that regulation, within the scope of that statute. And so the Commission was saying, we believe that the PURPA jurisdiction is coextensive in that sense with 205 because it uses the same phrase. And you have to remember that these regulations were promulgated in Order 69 in 1980. And at that time, as the Commission discusses in Order 671, there were no independent generators. There were maybe a few. There was no market for independent generation. So there was no such thing at the time as an independent charge for ancillary services like reactive power. It wasn't until the 1990s, I believe 1990 was the first time the commission actually approved a separate charge for reactive power. And it was 1996 when they issued Order 888, defining ancillary services and requiring them to be unbundled. But the commission made clear in Order 69 that it intended for electric energy under PURPA to be interpreted as broadly as electric energy under Section 205, which everybody agrees includes reactive power.
Thank you. Are there further questions?
Oh, thank you.
No thanks.
All right, I believe counsel for intervener wish to be heard.
Thank you, Your Honor. I'm Misha Tzitler for Duke Energy. I think the problem in this petition case is when counsel before this court is making completely different arguments from the ones that were presented properly to FERC. As Judge Silberman properly pointed out, the argument that was presented before FERC was that somehow comparability principle was a standalone basis for jurisdiction, and that doesn't really make any sense, which is why counsel didn't front it here. Now their argument on their lead point, this whether the sales were pursuant to a state regulation on PURPA, is somehow that because the interconnection agreement wasn't filed with the South Carolina PSC, that somehow it's outside of PURPA. There's nothing in the PURPA regs or any orders of FERC that require South Carolina to mandate the filing of this kind of agreement.
Did they make the argument, your opponents, that because nothing was filed in front of South Carolina, it was not implemented pursuant to PURPA? Did they make that argument in the rehearing petition, or did they make it only in this court?
I believe they made it only in this court.
Then why didn't you say that?
I believe I was attempting to say that, but I apologize. I was not as clear as I should have been. Now, I will say that if they did make that argument, it wouldn't make a whole lot of sense.
If my aunt had wheels, she'd be a trolley car. The question is whether they made the argument.
They did not make the argument, and the other argument they didn't make on their other element, of course, is the argument that they should win on this independent basis. This is an energy. Clearly, this was an independent basis on which they could win. So if they thought, FERC, hey, you messed up in your order, you didn't say that we should win on this independent basis, surely they shouldn't have raised that. This isn't a situation like Columbia Gas where FERC comes up with a new reason that you should lose in its rehearing denial, and then of course the parties justly agree. This is a basis on which they say independently we should win. Obviously, in that circumstance, they have the obligation to properly present that to FERC. Your Honor has no further questions. I will almost be within my 2 minutes.
All right, thank you. I think counsel for petitioner was out of time. We'll give you 2 minutes.
Thank you, Your Honor. I'd just like to focus on one narrow point, if I may, and it's as the court has identified, the essential constructs of the commission's decision on the point about pursuant to the state's implementation of FERC is all it says is that the interconnection agreement here is South Carolina jurisdictional and not FERC jurisdictional. And that's the sum total of the FERC decision. Counsel now, as they've made clear, have to defend that by saying that implicitly means it is made pursuant to PURPA. We've explained reasons why we don't think that's correct, but the essential problem with FERC is FERC never said that. There's nothing that they can point to in the FERC Commission's decision that actually connects the dots between a finding that it is non-FERC jurisdictional and subject to the Commission's jurisdiction with the determination that this fits within what the regulation actually requires, and that is it is made pursuant to the state regulatory's implementation of PURPA. And that's the essential gap. All of the other issues we're talking about are coming up because FERC never actually answered the question it needed to answer. We would submit the straightforward resolution of this case is to recognize that this argument was plainly raised in the rehearing petition. FERC didn't address it, and there should be a remand for FERC to actually address the question that the regulation obligates FERC to answer, and that council's argument now that doesn't appear anywhere in the
Just one curiosity before you sit down. Why did you not submit your client submit the interconnection agreement before FERC?
Before FERC?
Yeah, it's not in the record.
That's true, Your Honor, and that goes to the point of this, as we had understood, it was a Section 205 and 206 proceeding on the comparability principle. I agree with everything the court has said, that this that we have to get outside the regulation. But our point has all along been that this is no basis for us to be jurisdiction to be stripped, and that argument still holds, and is the argument.
My only problem with your argument is the phrase "all along."
Sorry, is the phrase?
Is the phrase "all along"?
All along.
Meaning you've been raising it all along.
Well,
that's
Your Honor,
my only problem with your argument.
Your Honor, just respectfully, we made this argument very clearly. Rehearing petition at 352 to 353. FERC did not address it. There's simply nothing that makes the essential connection between jurisdiction and what the regulation requires. And for reasons we've described, we don't think they can make that argument as a substantive matter. We don't think that's right. But the answer is FERC didn't do it. And so counsel can't defend what FERC did to try to match up to the regulation based on argumentation or analysis that FERC itself never gave. Thank you.
Thank you. We'll take the case under advisement.